Daniela Palacios, and tonight I will be talking to you about whether it is possible or not to bring an environmental claim to an international tribunal. And for this, let me first give you a little bit of background. I am a lawyer. I graduated in Ecuador. I'm a lawyer. I graduated in Ecuador, and I worked for 2 years at the Office of the Attorney General in Ecuador. That's where I came in contact with the Chevron case that we've heard about tonight. I also studied for 2 years in Stockholm and in London international arbitration and environmental law, and currently I live in the Netherlands. When I was in my second or third year of law school, if I remember correctly, I heard for the first time the words international arbitration. Then I thought things were pretty simple and they were clear-cut. There was an environmental harm, it had to be remediated. Arbitration was a good option for it. Little I knew back then. As years passed by and I continued my studies, I realized that things were a little bit more complicated than that. And for that, I'm going to use this case as an example, the Chevron versus Ecuador case. Why is this case so important and why is this case relevant for this? And the answer, despite all the complexities we've heard and I'm going to be describing shortly, the answer is rather simple, and it's because the pollution remains. This case, although it's often confused as one, have we heard already, there are more than one action taking place. I've used this chart just to summarize very briefly, but don't worry, I'm not going to go through all these cases, because on and all, between judicial proceedings and arbitration proceedings, more than 20 different cases have been filed. We have criminal actions, access to information, enforcement proceedings, annulment proceedings, international arbitrations. But there are 3 cases that are worth mentioning. And Pablo and Humberto touched briefly upon them. Can we move to the next one? To the third one. The next one. Perfect. So this is basically a timeline of the different proceedings that have taken place. Now, going back to the 3 proceedings I'm going to discuss briefly tonight. So the first one is the one that started in 1993 that Humberto and Pablo referred to. That case is widely known as the Aguinda case. It commenced in the courts of the United States in 1993. That case was dismissed on the basis of forum non-convenience. What this means? It means that the courts of the United States accepted Texaco's arguments that the adequate forum to try this case was Ecuador, because the alleged harm occurred in Ecuador and the plaintiffs were also Ecuadorian. So after 9 years of litigating this case, in 2002, the case was started again in the courts of Ecuador. Now this is the Lago Agrio case. This case is still pending, but as Pablo mentioned, the courts of Ecuador issued a judgment for $9.5 billion for remediation and compensation of the environment. Like I said, that case is currently pending because there is a constitutional action pending in the courts of Ecuador. But that's not it. There are also international arbitration, as you may find here. So we have Chevron 1, 2, and 3. 1 and 2 are already closed. The first one is a commercial arbitration. The second one is the first international investment arbitration under Ecuador and the United States Bilateral Investment Treaty. And the third one is what we call Chevron 3, just for practical matters. And this case is still pending as well. And this case it's also based on the Bilateral Investment Treaty between the US and Ecuador. Now, why is this third arbitration important? And it's because this is the one that includes the environmental claims. Although the tribunal, the arbitral tribunal in this case, has not yet decided whether it has or doesn't have jurisdiction to decide over the environmental claims, it has fully heard the parties on their environmental arguments. Both parties have been able to fully present experts and reports in order to assess responsibility. And here, allow me to make a quick stop. I'm not trying to point a finger at either party, or I'm not going to try to assess direct or indirect responsibility. Just for matter of explaining whether or not an arbitral tribunal can hear an environmental claim, that's where I'm going to be focusing a little bit tonight. Going back to Chevron 3. When the parties file their arguments, they both agree on one thing, and that's that the oil pollution remains. And the tribunal got to see and they got to assess whether or not there was pollution when they visited the Amazon region in June 2015. And there is one sad reality, and the pollution is still there, as we have heard before. I've also seen it, and it's devastating to see people living on top of what used to be an old pit or drinking polluted water. It's devastating to see how when you walk around the jungle, it's such a pristine environment, and yet you find crude popping out of the soil. Now, why is all this relevant? And like I said, the answer is quite simple. And allow me to go back to one point. How do we get an arbitral tribunal to decide over an environmental claim? It's not as simple as just bringing the claims to the tribunal, because we must remember that the mandate of the tribunal is limited to what the parties have agreed to bring to arbitration. So what's the solution in this case? What we can do in order to avoid this case from replicating and for taking more than 20 years to be decided, what we can do is we can incorporate a specific text as to ecocide of environmental degradation into the contracts or into the arbitration clauses in such a way that when a tribunal comes across this type of situations, they will have jurisdiction. Another example of what we can do is included in bilateral investment treaties or multilateral investment treaties. Take, for example, the draft model BIT from Norway. It was unfortunately tabled and it remained as a draft, but it did incorporate several environmental principles that are important, such as environmental protection. Also, the Permanent Court of Arbitration has a specific set of rules that can be applicable for the environment and natural resources. We can also look at those set of rules. Finally, I do believe that a crime can only be justified, and so on, we can use, a new crime can be justified, and new regulations can also be justified, as long as those set of rules can provide for enforcement mechanism. There are several environmental regulations. Take, for example, Stockholm or Rio declarations. They do incorporate environmental principles, but what they lack are enforcement mechanisms. What we do need is to establish an adequate forum where the parties can have their cases tried. I do believe that our international arbitration can provide such a forum, but we got to make sure that a tribunal has jurisdiction to do so. And by doing so, we can ensure that the environment is taken care of. Thank you.